have heard on several occasions from loved ones, persons who care, persons who may not know me beyond my public duties, and many who think that since these proceedings seem to be carefully staged to result in my removal as Chief Justice, it would be best if I just retired or resigned, rather than subject myself to an ill-motivated process. I have also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I've also heard commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in an outcome that was decided long before it started. Let me assure everybody that I am not seeking to cling to a title or a position. Again, resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you failed to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims they resigned or retired while the proceedings were still going on.
Chief Justice Araba Esaba Torkornoo Abusia. Enrada kasem ya pharmacy because hold press conference echichi insem bebree na insem no turu bi ya otia areho papa na mobo so na otu se personal interest bi so ehihye baabi abusia Chief Justice de kasemu no amafo akikase on resign obe resign anasa on resign na venue baabi committee ni choose ye a omokoka Araba Esaba Torkornoo ni nsem no personal issue bi a to say intimidate no a to say emu asefem payi saso so na yema mpani John ni Mahama awesa nasem agu feles fosukwache asum say Chief Justice Araba Esaba nsem no bekan no omra emeyi na no eba no abusia episode ni mabone tantam pupuduo pa che nsem polo a mabone bede me to apampentere so na bede adoma to so na mabone knan e de amount because case we no me much interested in it say Chief Justice obe resigning and also resign and no resign so a consequences be e na wo ho ema no abusia ta mchukuma me ntwa no mra me ba nkomo no ye de be hihye so. All right, abusia yaba ne yaba Milika Katchel say Chief Justice Araba Esaba Torkornoo abusia enrada offense am 12 emu nyina bihia na ese ode na de sede ene nema ha no ene baabia adu lodge baabia committee no omukaka na asem jeso kopuso wulem kura na ko hu nsem no de ekeka kone enema asem manfo bi ye personal interest bi na aso de nema bi siesie ne nsem bi a omudi hu hwane ade abusia maame ne ra hu yie pa saso so ena felix sukwachi aban kasamafo ye bampani John ni Mahama awese gu nasum say the Chief Justice ebeka no ono so emeka enche Ghana for say na ono so aban no ono so eka abusia tamuchukuma me nyeko Chief Justice Araba Esaba Torkornoo emra.
The committee has refused to allow me to go into the hearing with any family member. The work of the committee is being conducted in a cordoned high security zone on Castle Drive, Osu, when all Article 146 proceedings since 1993 have been held in facilities of the judicial service. It is hard not to reach the conclusion that the choice of venue against the backdrop of secrecy of proceedings is intended to intimidate me and to prevent any citizen of Ghana from knowing how the proceedings are being conducted. The Edu Lodge facility that the hearings are being conducted in featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history. It will be recalled that there was a Major Samakwa, a military officer who was killed with the 3 High Court justices, who was the director of human resource of GHOC. He was my uncle and my guardian when I entered the University of Ghana in September 1980. I was also living with him at the time he was abducted and murdered. Was Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there is no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge.
Abusia, maminya dajo na mjujwa ensemi ma kakra bi. Chief Justice Araba Esaba Torkornoo. Ne nsema o kan nyina ne se. Baby a omo kan asem eye Edu Lodge honom no. In the first place, baby a omo kan asem no, place bi a si ebeka ye 3 justices bi a yeku omo ahyi bi no. Abusia, na ne wofa eye military ayi eka ho a ye ku ne flash a 3 justices yi. A te se ne wofa ne efe ne Major Sam akwa. Somewhere 30th September 1981 na otene wofa ne nchen a okọ school. Nti sa place no lodge wana omo kan asem no se sa ehon owura ho no ma na ase ehu bi atono so a te se utu se amanfo person mu intimidate na se ebeka ya eye John Roris epenso na sansem no esi ye na ese no party sa wo power a omo sa de sansem we etata no so eye NDC fo. Nti sa place on so okọ ho no ma na ase bibi eye atono so ehu bi eye abono. Abusia enye easy yento ne nsem so abusia e say Chief Justice Araba Esaba obe resigning and also on resigning Ghana for asem say no kan e kire ye.
I have heard on several occasions from loved ones, persons who care, persons who may not know me beyond my public duties, and many who think that since these proceedings seem to be carefully staged to result in my removal as Chief Justice, it would be best if I just retired or resigned rather than subject myself to an ill-motivated process. I have also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I've also heard commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in an outcome that was decided long before it started. Let me assure everybody that I am not seeking to cling to a title or a position. Again, resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you failed to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on. Therefore, if false claims are made against a judge or commissioner or other public office holder subject to Article 146 proceedings just to achieve a political agenda, the solution cannot be to resign or voluntarily retire out of frustration, pressure, or fear. You would only subject yourself to two cruelties: a judgment based on false claims and loss of everything you have worked for. It may well be that the efforts being made are intended to frustrate me so that I resign, so that the architects of the scheme can go back into the media and say that the wild and unfounded allegations were not defended because they were true and I had no defense to them. As Chief Justice of the nation, who has been given the privilege and obligation to lead administration of justice, I should not turn tail and run when I know the implications of not defending false and unwarranted charges. If I resign under these circumstances, I will be saying that this flawed, unknown, and opaque process is acceptable. It is not. Finally, let me respectfully say that the current bizarre proceedings I have brought to your attention present a twist to our nation's democratic journey that we all ignore at our own cost. My humble view is that Ghana has come too far in the 33 years of the Fourth Republic not to be concerned about the unconstitutionalities that have been designed not to affect just me personally as Chief Justice, but all judges and public officers subject to removal processes of Article 146, if this one is successfully carried out without being questioned. Behind me is every judge in the country. Behind me is every commissioner or head of an independent constitutional body in the country. If successful, it will be tried on anyone.
All right, Abusia, I say my mama tofa ema. So okay, constitution na etifi ho no jansi ho no baby a. O say Chief Justice Torkornoo na e kan. We Chief Justice. Na say abai dey asem bow. That's where the man you want na you abi say obe resign am. O title ene udi blani nimdia wo baby a wo aba mu bia no. Ye gifri wo nsem. Ti enye easy sa. Ma mo expect say on resign na ade ade ne ahunahuna no. Enye no na ahunahuna no. Enye ne hu. Nti baby am pese mo de asem no keka ko bi ono wata mu chuku wo hwem. Ana some on resign onya de mfrim. Di bra baby a woduru no. As wabo bra no akoduru hero ni ese te wabadan na wasa ba zero. We are my teacher ye. A bank teacher near you wadi. I bet enough ya be my baby na bet my position ni di break crow bia akrew. Untimi ka say oh may you retire Chief Justice there be ensida. Ye yifu o resign ya yi sa de man nyina free so. Ka say baby crow mo sa de ni krampo. Abusia enye easy. Sa na ye man panyi John Dramani Mahama awesa ensem egu Minister of in charge government and communications eye Felix Fosu said the Chief Justice Araba Isaba Torkornoo ebe kan no onko omeka sei enche Ghana for abusia yentie Felix Fosu so emra.
In the last few minutes, many of you in the media have reached out to me seeking to inquire about what government makes of the press engagement that her leadership, the Chief Justice, just had, which bordered on the petitions brought against her and the deliberations of the committee tasked to look into the matter. Ordinarily, if the matters were left to the content of the petition and the processes being undertaken by the committee, we will not have cause to comment because those are matters beyond the purview of the president or the government. But a number of things were said at the media engagement that, if left uncorrected, could create an erroneous impression and project government in a very unfair, unjust, unwarranted light. To begin with, let me point out that as yet, nobody has been able to ascribe any known verifiable constitutional breach to the president in the way that he has handled this particular matter. From the very first steps in this matter, the president has kept fidelity to the constitution and has respected the spirit and letter of the constitution. Everything he has done has been by the book. That is why all those who have commented on the matter, including Her Ladyship the Chief Justice, have been unable to point to any specific provision under Article 146 that the President has been in breach of. Second, in terms of confidentiality, the President has acted strictly in accordance with the Constitution. At no point in time has the Presidency put out anything in any way, shape, or form that remotely resembles any of the contents of the petition. And the only communication that has gone out on this matter have been about the steps that the President has taken in accordance with the 1992 Constitution, Article 146 to be precise. 3, Her Ladyship the Chief Justice all but insinuated that there was some political agenda at play to oust her, and that this whole process is a result of sin. Let me place on record, without fear of contradiction, and let me be clear that no such political agenda exists. His Excellency the President took an oath to which he was incidentally sworn by Her Ladyship the Chief Justice herself. And in that oath, he swore to abide by the 1992 Constitution. He is enjoined to act a particular way when he receives petitions of the sort that he has received. And that is all that His Excellency has done. He has had no choice in the matter. The President cannot say that he has a view about how things should be done, and therefore if petitions have come, he will fail to act. If he did that, he himself would be in breach of the Constitution, and therefore he has been enjoined to act as any responsible leader or President of the Republic of Ghana would be required to do, as stipulated by the 1992 Constitution. The fourth point is also that we cannot have a sacred cow mentality in the way that we handle state affairs. Every single public official, from the President to the Speaker to the Chief Justice to Supreme Court judges to ministers to all public office holders, are bound by the provisions of Ghanaian law. Indeed, it was the former Australian Prime Minister, Kevin Rudd, who once said that when you join the game, you play by the rules. So no public official is allowed to raise him or herself above the laws of Ghana. It does not matter how sensitive your position is. Once Ghanaian law dictates that certain processes be undertaken in respect of some alleged misconduct, the rules must come to play. And that is the only guiding principle that President Mahama has operated by in all of this. So any claim, any inference, any innuendo, any imputation of a political motive to the President in respect of these processes are unfounded, they are false, and cannot be allowed to stand. And I wish to place that on record. As yet, absolutely no evidence of same has been furnished in any way, shape, or form. Unfortunately, Her Ladyship the Chief Justice herself has added to this commentary, which initially was the tone of elements of the opposition. And it is deeply regrettable that this should happen when the President has been above board and conducted himself in strict compliance with the Constitution of Ghana. The other point that I wish to also place on record is that the attempts to link the dastardly killings of some Supreme Court judges and a military officer to this case are most disingenuous. To begin with, this government and President Mahama have nothing to do with the killing of any judge. Second, there's absolutely no nexus between the petitions that have been brought and that unfortunate incident in our past. So any effort to link the two is regrettable and should not find space in this sort of discourse. It is most undesirable, it is most unacceptable. Now, the venue in question is the Edu Lodge. Yes, it is close to the Osu Castle, which used to be the former seat of government. As I speak, there are government agencies that operate there. So it is a public place. The Osu Castle is a public place. You can go there to conduct official government business. Beside it are private residences owned by Ghanaians who move freely in and out of their residence, even though they are situated very close to the Osu Castle. So the impression that a facility in the vicinity of the Osu Castle necessarily makes it intimidating or foreboding is completely misplaced. It is unfair. It is not justifiable. Now, Edu Lodge is a state facility which is often used to house high-ranking officials who visit the Republic of Ghana. It belongs to the state. The decision to use that place was not that of government or President Mahama. The committee requested that they needed facilities of a certain status that could house their activities and that could facilitate a smooth running of the proceedings. And that facility was available. It is equipped with modern amenities that will facilitate the work of the committee. And the state only offered it upon the request of the committee. Let me also state that that facility is not intimidating. It is like any regular state facility where business can be conducted to the extent that it is put in the right shape. Wherever these proceedings were held, it will still be in camera, as clearly stipulated in Article 1468 of the 1992 Constitution. So that the proceedings are being held in camera is only in compliance with the Constitution. So it doesn't matter where it is held. And any security measure put in place is only intended to secure the place so that persons who are not authorized to be part of the proceedings do not come there and create any inconvenience. I believe that even if the hearings were held at the court premises, it will still be under significant security controls to ensure that only authorized persons have access to the place. So to describe Edu Lodge in the terms that her ladyship, the Chief Justice, did was most unfair and unjustifiable. It seeks to obscure the process and bring in unrelated matters that seek to cast some aspersion or ill motives on government for affording the committee a place to do its work. As I indicated, we have no interest in violating the Constitution by going into the merits of the case. And that is why government has refrained. Let me put it on record that government itself has had cause, indeed the president himself had cause, to lament the way in which some correspondence around this matter got into the media. You will recall that the very first sign of any leakage was the letter that the Chief Justice wrote requesting for copies of the petition. Before the letter got to the presidency, it was in the media. And you recall that in the president's response, in which he also took the opportunity to forward the petition to her, we raised that issue, that it was not acceptable. Indeed, we had cause, the president had cause then to ask his executive secretary to mark the documents that were being sent to the Chief Justice in order to guard against any leakage. So at no point has anybody leaked anything. Also, it must be noted that even the media houses that first broadcast the content of these petitions were media houses that you can say are aligned to the opposition. And they are the ones who have gone to town with this sort of thing. So to attempt to cast aspersions on the presidency is most unfortunate, and it causes what should be a smooth process leading to the determination of the merit or otherwise of the petitions that have been brought. So in summary, I would say that what has happened today is most regrettable. And as government, or as the president, President Mahama is committed to upholding the rule of law. We cannot have a situation where, depending on who is involved, the constitution is set aside. All Ghanaians are equal before the law. In the same way that our courts have dealt with individuals in accordance to law, if members of the judiciary themselves are alleged to be engaged in some wrongdoing, the processes laid down and spelled out by the constitution ought to be respected. And that is exactly what has happened.
Abusia Minister in charge, Government and Communications, AFS Sukwachi, and some say, no see a man penny don't domini Mahama, every Saguna Suma, or Becachere and Abusia. Mamma Monotofan. First for Suka Ekasemun was say the Chief Justice Araba Esaba Torkornoo a ya suspending a all can say me so baby a ye de adu lodge ho no de nasem no ko committee for ye man pani don domani mahama and choose sa adu lodge ho no e ma no ho ne ben osu cast ho no na committee for na choose ho no because of say security wise in team because on protection e wo ho no and even kura ho no nsa nye baby ehu even civilians for kwa CCTV ho and security esa wo no e tight and nti e na ma committee no omo ko choose ho a omo yes ana mom nya say bia omo di behunahuna na omo di be intimidate no ana say bi sentesa abusua se wadwen e conversation ho e ma me na share video yi ama afoforo enya bi hwe follow all the social media platform as Van Dyke GH na subscribe to page no anytime we ever drop latest update no on sa kameda ase makrao